Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about divorce and family law with an emphasis on questions from viewers and listeners. Joining me as always is my co-host Jesse Barrientes. Jesse, how you doing?
I'm doing great, Dave. How about yourself?
Very good. Good to see you.
Awesome. You as well.
Okay, we have a lot of information that we have to cover.
Okay.
And a little bit of time to do it, so let's get right to it. Got a letter from Kevin in Steger. Kevin has two kids, Jesse. One is a 6-year-old boy who is into baseball, and he's got a 9-year-old daughter who likes to draw. He works as a medical tech, and he earns approximately $60,000 per year. So he's doing okay on his own. His wife is educated, highly educated, but refuses to work. Instead, she decides to raise the children and stay at home. He's considering fighting for what used to be called child custody, and he wants to know what is the best interest of the child standard that he's heard about, which is a factor in determining how custody is decided.
Sure. So they're still married then, from what it sounds like.
Still married and still living together.
And still living together.
Same house.
Right. Well, first let's tell everybody the way, and it's going to probably go through the questions. Since January 1st of this year, the whole statute, Illinois Marriage and Dissolution of Marriage Act, has changed. It's no longer called custody and visitation, but the allocation of parental rights and responsibilities, and that's broken into two prongs. One is decision-making, and the other is parenting time. Decision-making goes into four parts. It goes into decisions as it relates to religion, decision as it relates to medical, decisions as it relates to education and to extracurricular activities. And those four areas can be divided up any which way. We'll probably talk more about that later, but just so that the folks know at home, it's different. But realistically, a rose by any other name is still a rose. People are going to be continuing to call it custody and visitation for a long time. And parenting time is just that. It's time with your child, and that can go any kind of different ways. But with respect to the best interest of the child, custody is always a tough thing, and I just called it custody because that's what people know. So we'll look at it with the mindful note that it is the allocation of parental rights and responsibility. That the court looks at several different factors to determine who is going to have more parenting time with the child or not. And they look at the parent's desires, and okay, we already know what that is. That's a pretty much an easy one. He wants them and she wants them. A lot of times people want the children because they want the child support that kind of goes with it. Sometimes it's not the case, but sometimes it is.
Then here we have cause though.
Sure.
Kevin thinks that his wife is manic depressive and has episodes of highs and lows, and that could affect her ability to parent with the children. So there is a concern, and she won't seek treatment either, according to him. So that's why he thinks he needs to take over the custody and be the custodial parent in this particular case.
Before I get to the other kind of factors that the court looks at, let's look at that. Okay, we think, well, don't we all have highs and lows? Don't we feel better sometime and worse others, peaks and valleys? Someone that's not diagnosed, he's living with her. He probably lets her take care of the children. If she's taking care of them, he's going to work. Okay, apparently there's no problem with that. So there's people have to look at what these are, and each situation is different. And so if he really had a concern, I don't know. I mean, I'm just telling you, for me, if I had a concern, I probably wouldn't leave my children alone with the other spouse. I see this a lot. I'm also a mediator as well as a guardian ad litem, and we'll probably talk about that. I don't know if we have a question coming up in terms of what that is, but people have to really look at it. A lot of times when people get ready to do a divorce and they're jockeying for position, all these things kind of come out. Now, it might be that there's an issue. So let's look at the other factors. So we talked about the preferences of the parents, and then there's also the preferences of the children. That's just, a lot of people think, okay, well, my son or my daughter, they want to live with me, they think that's it. No, that's just one factor in a list of factors. The older the child is, the more weight that the child's decision has. Obviously, a 3-year-old isn't going to carry any weight kind of at all.
Well, we have 6 and 9.
Well, we have 6 and
particular
9,
case.
so somebody older, or maybe a 15 or 16-year-old, that's a little different. The older, the more weight it is. But that's just one factor. The court's also going to look at if there's any history of any type of domestic violence or anything that happened, and the court's also going to look at any other factors that they want that would have a bearing on what's in the best interest of the child. Again, it's all about the children. It's not about mom. It's not about dad. It's not about the convenience. It's not about driving an hour or 2 hours here or there. It's about what's best for the child and nothing else. And so it's really difficult with just those kind of facts. You never can tell. And it really depends on where you're at, what county, and who your judge is. You have 5 different judges. You have 5 different takes on what it is. So looking for the best interest standard, I mean, it just, we don't know really enough. However, the thing to focus on in any divorce with children is, again, what's in the children's best interest. Don't use your children as a pawn. Don't talk bad about your spouse in front of the children. Hey, they're the innocent folks in all this.
Right. All right, let's move on to another question. This one comes from Karen in Orland Park. By way of setup here, she has a 16-year marriage with 3 children, 14, 12, and 8, 2 boys and a girl. The kids attend a private school, and they're very involved in the church. No one can believe that the couple is struggling through some marital discord here. The finances are at issue. The husband earns a modest income, yet attempts to provide the best things he can for the wife and the children, and the wife chides him for not being able to earn more. So her question is, specifically, there's a court-appointed guardian ad litem in the case that the judge ordered. She wants to know, why does she need this, and who in the world is going to pay for it?
I believe I can answer both of those questions, Dave. As I told you before, I'm a guardian ad litem in DuPage. And there's really 3 things we need to look at. There's a guardian ad litem, which is an attorney with special training that gets appointed by the court to do an investigation and report back to the court on what that person believes is in the child's best interest. Then let's go to the other kind of extreme. There's an attorney for the child, and sometimes when there's older children, the court may appoint an attorney for the child, and that's just that. It's an attorney for the child. It's just like the attorney representing mom or the attorney representing dad, except that attorney represents the child or the children, and the children or the child is that attorney's client, and they have to take direction, and they have to listen. All right, then we have in the middle, which is a child rep. Child rep is kind of a cross between both of them. Child rep can do an investigation, kind of make a report, but can't really be called to testify, can file pleadings in the case, can participate in the trial, where in terms of asking questions of witnesses, calling their own witnesses, whereas the guardian ad litem can't. And again, so that's kind of in the middle. But because the parties are not in agreement, now probably what happened first is that the parties were referred to mediation at some point, and it
was fruitless.
It's fruitless, and it didn't work. So
Nope.
The next step then, because that's the least expensive, so the next step is to appoint this guardian ad litem, this attorney, to go out and do an investigation. The guardian ad litem is really the court's right hand, the court's witness. The judge can't go out and do all this investigating. They have all these cases, and so they rely on the report of the guardian ad litem.
Wouldn't that be something?
That would be something, wouldn't it? But so
who's going to pay for it?
Well, the parties are going to pay for it. Generally, what happens is they split it 50-50, or if somebody's making a much disproportionate share of money than the other person, they'll split it. They can split it any other way, or they can even make one person foot the bill for the whole thing. It just depends. But the court doesn't necessarily have to listen to the guardian ad litem or to the recommendations in the report. Chances are they probably will. But they don't have to. Just because the guardian ad litem recommends A, B, or C doesn't mean the court has to follow it. But since it is the court's witness, the court probably will. And that's because the parties can't come to an agreement on their own. I want to tell our folks at home, our viewers, that look, it's better to have a decision that you and your spouse come to, that you both came to, rather than having a judge make a decision based on a thumbnail sketch of your life. And neither one of you are going to like it. One of you isn't going to like it even more than the other. But you need to be able to resolve these issues.
Are there any guardians ad litem that will work on a pro bono basis?
The court can appoint, in certain cases, guardian ad litem on a pro bono basis, but that's up to the judge.
Okay, I think it's important to note that guardian ad litem fees, child rep fees, those are non-dischargeable debts. So if it does wind up breaking the couple's back financially, those debts are not going to be eliminated in a Chapter 7 bankruptcy. They're going to survive.
Right, they're going to have to pay it.
Yeah, okay. Another one here from Lindsay in Blue Island, and this is a gentleman. He travels for a living. He's only around town 2 days per week. The parties are officially separated 9 months ago. Not much communication since then. Support is not really happening at the rate that the parties would like. The wife controls everything. Husband has zero say in anything affecting the children, and he wants to know, and we're back on this custody issue to a certain extent, he wants joint custody. So he's not looking to run the show, he just wants to have a say, and he wants to know, why is that so hard to accomplish? He just wants to have input, and he's not doing anything harmful, so why can't he get that input and get it quickly?
Okay, remember we said earlier that now it's the allocation of parental rights and responsibilities, decision-making in those four different areas. Before, it used to be joint or sole. Joint was the non-custodial parent, the parent who didn't have the children most of the time, was able to have an input in those decisions that we're talking about. And sole was the opposite, didn't really have that. And that was really the only difference. But with the allocation of parental rights and responsibilities, the judge can allocate any one of those. So the judge could have, for example, the husband solely responsible for the decision-making as it relates to religion, and mom solely responsible as it relates to medical, and then both of them joint as it relates to education and extracurricular. Or one person could be sole for all of them, one person, there's just many combinations. But here's the deal, and I don't know if we have the information, did the gentleman have a say-so before the couple split? How did they interact? Did he have an input, or did just the wife continue to call the shots? A lot of times that's what happens. What does a husband do or a spouse do? They go out and work, and the other person is the one that's taking care of the children. They're the one that make the doctor appointments. They're the ones that really call the shots and make the decision. So if that's how it was during the course of the marriage, and the court's going to look back the last 6 months or so between how that was, it's probably less likely that that will happen.
According to his email, the wife was in control of everything and doing everything while he was traveling. So now he feels kind of with this separation, and he's not seeing the kids as much, that he's powerless in effect.
Well, there's not about being powerless. Everything is, it's going to happen. It happened before while he was traveling, and it's difficult if he's traveling all the time and he's only around just a couple of days, 2 days a week. How is he going to be able to have that kind of an impact?
Well,
does he know? Well, here's the question. This is what I would always ask. I would ask, okay, all right, what school do your children go to? What grades do they have? What classes are they taking? What medical conditions do they have? What prescription medical are they on? When was the last time they were at the doctor? When was the last time they have a cavity? If you can't answer those questions, that's going to be a little concern for me as the GAL. And again, I'm just trying to find out, because if you don't know the answer to those questions, that tells me that you have not had that involvement.
Right. He has not had that involvement, but like many men who are in this situation, they offer to change their situation, change their job, less travel, closer to the family, more involvement, weekends, day during the week or two. They push for more, whether or not they could actually handle it or will actually do it if it's ordered, but they talk that they want to do it.
Well, that's going to be up to that's going to certainly be up to the judge. I used to tell people all the time, and before the law changed, when we had joint custody and sole custody, if I represented, say, a wife, and she said, hey, the husband never made these decisions, and okay, so we were able to resolve it, and did agree to joint custody. The wife did, because what I've told some of them was, okay, what's going to happen is after the divorce is over, it's just going to go back to the same way that it was.
But wait, can't you allocate things during a marriage different than how you're going to allocate things in a divorce?
Sure.
I mean, why is the guy stuck with the same old just because wife was doing this, that, and the other? He wants to participate now.
He's not stuck with the same old, but if he's only around 1 or 2 days, it's not, again, in the best interest of the children. It's not feasible. It's, and again, what's going to happen is the court, under the new law, an allocation judgment has to be entered within 120 days from the time the respondent is served. That's not really a whole lot of time. And the court can enter a temporary allocation judgment without prejudice till it gets done, but they want to make sure that the children are taken care of, that they have figured out who's going to make these decisions in the interim before everything is over. And what will happen is the judge will have a mini hearing on that, or a hearing on it, to determine those factors and to find out, hey, who's been doing what for this last amount of time. Okay. And, you know, sometimes the court might split the baby and, again, give somebody one thing, somebody another thing, and both of them together. It just really depends. They don't have, each case is very specific, and it depends on where you're at and what judge and everything else, and how the parties really cooperate with each other.
Sure enough. Okay, Terry and Joliet, let's talk about him. He's been divorced for 4 years. The child is now 10, and the judgment calls for alternating weekend visitation. It was called visitation back then. It has not been consistent. Husband has struggled with alcohol, and the wife refuses to allow visitation when she sees he's in an inebriated situation. Husband accepts his weakness. He has taken corrective action, and he now wants to get back to the schedule that was in the judgment. And his question is, what recourse does he have because his ex-wife is not honoring the visitation schedule set forth in the judgment, because she's relying on this alcoholism that has now been under treatment.
Okay, that's not too bad a way to kind of handle it. From what you said, I understand that nothing has changed. Nobody went back to court, so the judgment gives him alternating weekends, and that's it.
Right.
It's just that the wife or ex-wife had refused when he was inebriated to let him have the children, which, you know.
She got some advice from her family and friends that said, refuse it until you're convinced that he's sober. And until that happens, refuse it, and make him come back into court. So his question is, do I really have to come back into court, or what can I do?
You know, you really can't blame somebody. If you're coming to pick up your kids and you're intoxicated, I'm not going to let them in the car with you. That's just not going to happen, okay? And that's the difference what we're going to talk about, is a petition for rule to show cause.
Yeah, he's not intoxicated anymore.
Well, right, since nothing's happened, he could file a petition for rule to show cause. A petition for rule to show cause is a vehicle by which somebody can enforce the order that was previously entered. And what happens is, simply in this case, you'd, I guess, would allege, okay, on this date, the judgment for dissolution was entered. This paragraph or article or subsection gave him this visitation, that the petitioner, I'm guessing the petitioner was the wife, has refused visitation on this date, the other date, or whatever date, and that she should be held in contempt, that it was willful, for refusing to allow him to exercise his visitation, although it's parenting time now. So dependent upon what county you're at, the court will issue, when you go in on that motion, what they call a rule order. Now, whenever you file a motion, if you file a motion, you have the burden by establishing, generally by a preponderance of the evidence, what you've alleged in your petition. Petition for rule, when it's verified, depending upon which county you're in, the court can enter a rule order which changes the burden to the other person to show cause why they shouldn't be held in contempt. And then if they're able to show it, then the burden shifts to the other person. And so...
what's the judge going to do here, though? Can the judge order a toxicology report?
This is not one of those, unless there's another motion. First of all, the judge can, I think, let's be honest, I think they could pretty much do anything. But in this case, for a petition for rule, if you're just doing that, it's just she didn't comply with the order. That's all that is. She could file a petition to modify the parenting time. She could certainly do that. Now, whether or not she'll be held in indirect civil contempt for violating that order, if she says, okay, he came on these dates and he was intoxicated, I'm not going to give my children to somebody and let him get in the car who's intoxicated. Okay, well, depending upon the proofs, the court might not find her in willful contempt.
Would the court at least allow for supervised visitation?
But we're not even there. There's nothing before the court on that. It's just, if we're just talking about enforcing it, the judgment is what it is. And so if he's just trying to enforce it, a petition for rule is what he needs to do. Anything
Okay.
could happen from there, but you don't know until it happens.
Okay, let's move on to Laura from Chicago. Laura is seeing dollar signs, according to the email. She married a Chicago police officer.
Well, then she's not seeing dollar signs.
Well, he's nearing retirement,
Okay.
so yes, she is. He handles homicide cases for 10 years, and let's see, he deals with the gangs, violence, and all that for the last 3 years. However, he has not faced any kind of issue with his wife in terms of domestic violence or anything like that. She wants blood because he now has a girlfriend, a very young girlfriend, a 28-year-old female. And the question is, can she get into the pension that he has with the city? She's been with him for 29 years, married for the last 6. That's the key. With him 29, married for the last 6. What is she looking at in terms of money?
I've got good news, bad news.
Okay.
Good news is she's going to be entitled to the spousal portion of his pension. Bad news is it's only going to be for the 6 years they were married. Now, the new law, I believe, has changed, so basically, if a dissolution case, a divorce case continues to drag on, it's going to be from the date of filing. To be able to do that. Before it was, hey, when the judgment for dissolution of marriage was entered.
So you don't reward somebody for dragging out a case.
For dragging
to
out a
increase
case,
the
and that's
pension
kind of
profit
the
sharing.
reason why, you know, kind of did that. So it'll be the 6 years, and they're, you know, they'll have to do what they call quildro or quadro, qualified domestic relations order, or qualified Illinois domestic relations order, and it'll be just that portion of the 6 years, and that's really about
Well, that's the pension, but if they were going to seek some sort of maintenance order, can they use the lack of maintenance or the waiver of maintenance as a way to maybe increase the size of the pension allotment? Can they negotiate those two variables?
Anything that can be negotiated, and you know, we're assuming here that everything is going to be 50-50. Well, it might not be 50-50. We don't know if they have what they have in savings. We don't know if they have a home and if there's any equity in it. We have an idea well, we don't even know exactly what he makes and what she makes.
Well, he's nearing retirement, so he has a pretty good salary.
Right.
And he was very, let's just say, thrifty as far as commingling things. He kept things separate for a reason.
But that's okay. But again, we don't know any specifics, so it really depends on the specifics of the case because we don't know. The court is entitled to consider somebody's non-marital property. Generally, when people get married, everything acquired during the course of the marriage is considered marital property or marital debt. Again, there are exceptions to that. Non-marital property are things that you've had before the marriage. So let's say I had a Harley that's worth $100,000. Okay, all right, well, that's before the marriage. Okay, or maybe I had $1 million in an inheritance in a separate account before I got married. Okay, all right, that's my non-marital. You're not going to get any of it. However, the court is entitled to consider a party's non-marital estate when they divvy up the marital estate. So if I have $1 million, $5 million, $10 million in non-marital property, and the marital estate is worth a couple $100,000, who do you think probably might get the lion's share of that marital estate? It'll probably be the other spouse. But again, we're just kind of projecting here, kind of speculating in terms of this case. So,
And that was always part of the statute, correct?
oh, that was always
This is
part
not
of that's right.
part
It
of
hasn't
the new,
changed. And it should be because we're dividing things up the way that it is, and that's what they can consider because it's all about equity. It's all about dividing up the pie.
Okay. Darren in Lamont, email from Darren. His attorney is threatening to withdraw because Darren can't pay his bills. What are his options? And a little background here, Darren says he's a seasonal worker and he he's hurt by the economic crisis. He's trying to find a higher full-time job, but he can't. He wants to continue with the divorce case. He wants the attorney to stay on, but he can hardly make his rent, and the attorney is obviously threatening to to withdraw if not paid.
Well, I'll tell you what a judge always used to say. Can't say who he is or what county he's from, but and probably a couple.
You can say it.
Couple of them will say it, and it's there's no more such thing as forced servitude. Okay, you can't force somebody to work for nothing. People get paid. When you go to work, you expect to get paid, and attorneys expect no less. A lot of people think, oh, just because somebody's an attorney means they have a lot of money. That may or may not be the case. But essentially, if you entered into an agreement and that's what you agreed to pay, that's what it is. Sometimes I tell people, I say, hey, look, you go to work, you expect to get paid. Okay, I expect the same. But why don't you go to your employer and give them half of your paycheck and say, hey, thanks for giving me a job. Oh, well, that's different. No, it's not. It really isn't. Okay, so if the attorney wants to stay on, he certainly can. He doesn't have to. He's not going to be required to work for free.
What about cases where you're closing in on a trial date and an
Depends
attorney
on the
wants
judge.
to petition to
Right.
get off and they can't always get off that case?
Well, that's true if you're really close.
Now we have the indentured servitude.
Well, no, not really. Okay, you may not. All right, but here's
You
a question.
ethically have to represent.
Here's a question for the people at home to ask if they were in that situation. You haven't paid your attorney. The judge hasn't let him to come out, let him get out of the case.
Right.
Do you really want that person representing you in the trial?
If you know that you're not going to pay that attorney and you don't want to represent yourself,
Do you really? I don't know. I think that's a question you should ask. But again, each case is specific, and again, it just depends on where you're at and what judge it is. They can certainly let you out. They don't have to.
okay. Just a few minutes left,
Okay,
Jesse.
yep.
Bonita in Cicero, she is not legal in the country, but she is married. She wants to know, will her divorce case affect her immigration status?
No, you can get divorced. That's not going to be an issue.
Well, there's going to be a court order,
Right.
and it's going to be recoverable.
You could still get a divorce. I mean, the thing for her to do, obviously, and again, I don't know anything if they have children. I don't know what her circumstances are. I'm not an immigration attorney. So probably what she should do is to talk to an immigration attorney to find out what she needs to do if she wants to stay here. And again, I don't know if there's any children involved or how long she's been here or what the deal is. But getting a divorce isn't going to affect her. It's different if, for example, somebody commits a crime and they plead guilty or they're found guilty, then that might have negative consequences if you are not legal.
Okay. Talk briefly about the court costs involved in a divorce case. I know those keep escalating year after year. It seems almost cost prohibitive for somebody to get
I just filed one today, and they add some extra fees that are, there's so many things that are kind of added on, fees and all that stuff. Anyway,
Are we approaching $1,000 in court costs and
no, just for the
transcript
filing
fees?
fee. No, not for the filing. So
No,
just,
the entire court cost.
Oh, the entire, well, that kind of depends on what you do. I mean, the filing fee, where did I file it? I think it was DuPage. I think it was $301. But that doesn't count the service fee. That's not going to account for anything in terms of a discovery, if we do depositions, or if we have to hire a court reporter when we do the depositions, or anything like that. It really just depends. Again, the best thing for people to know is it's better for you to come to an agreement between the two of you. It's better for you both to work it out so you have a say-so in what those terms are than it is for someone you don't know to make a decision on those things that the person really doesn't know about.
And this could be possibly mediation prior to a case being filed officially?
That's true. You could do private mediation. That's a good way. It's a neutral party who helps the parties come to an agreement. The mediator is in control of the process, and the parties are in control of the outcome.
Okay, and real quickly, a question I get asked a lot. What's the time frame for an uncontested or agreed upon divorce?
If everything is agreed upon, probably get it taken care of within 30 to 60 days. There are some places, I believe in Will County, even if you file it, you have to wait 30 days before you can get divorced. You do the prove-up. You might be required also to take a parenting class, so you have to factor that in. That'll cost you about $85 or so a piece.
Sounds good, Jesse. Great information
All right,
on
Dave.
divorce and family law. We'll see you next time on Legal Action. Take care.